we are not all attorneys, although there may be some on, but there is actually nobody on tonight. Everything discussed is just personal opinions and may not stand up in court. Our hope is that we can open these discussions up for a broader audience and have these ideas recorded for the next generation. There are some great high profile boundary surveyors and even college students from across the country on this Zoom meeting. And I hope that we can all gain a bit of knowledge from these discussions. So Chapter 10 tonight, recording and preserving evidence. And if you actually look, they forgot to put the space between and preserving evidence up on the bookshelf, the virtual book. I just saw that when I was looking there. That's pretty funny. But so it's not a super long chapter tonight either, but it's about what, 20 pages or so, 19 pages. So should be a fairly easy conversation, but let's get started.
This, like a couple of the other chapters, is going to be so area dependent of where you're practicing, right? Yeah. How do you preserve it in yours? And we've had a lot of conversation about the uniqueness of Utah, where that survey gets filed, again, filed, not recorded, but filed at the county surveyor's office and isn't part of any official deed record or anything like that, right? So preserving that evidence in Utah is unique in that sense, and I know every state has its own nuances there. I just want to read the first couple of paragraphs here of kind of the caveat they give, and then we'll go through the principles, and then again I'm just going to rely on you guys to kind of help bring that conversation through as we go through the chapter, to kind of share your experiences and the way things happen in your areas. It says the scope of this book has been directed primarily toward presenting students and surveyors with an appreciation of what is expected of professional surveyors and attorneys when locating, relocating, and litigating identified parcels of land, together with the possible insight into the role of attorneys in this process. Although this chapter may not be the longest, it may well be the most pertinent to the surveyor. In the location or creation of original parcels, the emphasis should be on adequate, precise surveys and the placements of substantial monuments that will permit their future identification. In retracing land descriptions, the emphasis is on accurate surveys that identify the original monuments and lines. This requires that all conveyances be related to known monument positions that are usually located in written descriptions. If monuments are destroyed, certainty of location of the parcel being located may be compromised. The object of this chapter is to discuss suggested methods for preserving evidence called for in former conveyances and subsequently recovered by the retracing surveyor. The chapter will also discuss the professional duty of the surveyor in preserving this evidence as the authors see this duty. And so I wanted to hit maybe 2 or 3 main points as we talked about, to inform the way we read this chapter. The first being preserving evidence through our field notes. How are our crews preserving that evidence, either for us from the field, or we've talked about field notes or any sort of survey reports that go along with that survey. I'm going to include those all in kind of one group as we have a discussion of how does the crews preserve evidence. I'm going to share I kind of talked with Trent a little bit as we started just today. I ended up out in the field there for a little bit to go search for a section corner. So the section corner was located in the last year. The tie sheet, and again, the uniqueness of Utah is that tie sheet is held by the county surveyor, has not been updated since 1986. Tie sheet showed the monument is 2 feet off the back behind the curb, but the monument was actually found in the middle of the street level with the asphalt. One of the tie sheets called a bearing of 285 degrees, but it was really almost 285 degrees, but it was really almost 200, right? So as we took that bearing from a tie, I'm going almost in the wrong direction, right? So I was with a younger crew. How did they preserve that evidence? Marking up the street, setting some paint lines in the curb. There was an X etched into a chain link fence post. So we flagged that up so it was easy to see and find. It took us a little while to find it. So in the field, preserving the evidence, this is what they did. This is what our crews can do, right? A lot of states have some sort of mandatory section corner tie sheets that get refiled or re-recorded. And certainly we will be reporting back to the county on this one. But that first kind of how we inform this discussion is recording and preserving evidence in the field. The next one that I kind of want to just have in the back of our minds as we're talking about a lot of stuff is how are we as licensed surveyors preserving and recording evidence on the face of our survey? What are we calling out? What notes are we making? What narratives are we making? References to surveys. How are we calling out those surveys? How are we calling out deeds so that they're easily findable and preserved, right? And then the last little bit is kind of anything that isn't encompassed in that. I mean, field and office encompass all of it, but this book, this chapter just offers some insights into other ways we're preserving evidence, and also talks about ways in which we are finding and looking for that evidence. Jumping back into the book here, measurements to preserve any monument position are of two types: those made prior to conveyancing and called for by the conveyance identifying monumented corners in the reference documents and maps, and two, those conducted after completion of the conveyance that were intended to identify the original position of the original monumented corner and measurements to any subsequent monument of a retracement. Okay, I just want to point that out real fast here. And then like we've done in the past, and this one again is much shorter, let's jump over to our 4 principles that this chapter covers. So principle 1, a second generation corner monument for which there is a complete chronological written history from the original monument and for which this history is reliable has a legal dignity equal to the original monument. Principle 2, a found monument without a complete authenticated chronological history from the original corner monument is of little value as evidence of the original corner. Other corroborative evidence may be used to provide for the acceptance of that monument, even though the monument may not be original. Principle 3, evidence of original surveys collected by private surveyors and private surveys should be made available to other surveyors who wish to examine that evidence. And principle 4, surveyors and the attorney should consider the totality of the evidence recorded and used in the determination of boundary issues in retracement. So jumping in there, let's just kind of open it up for a second here. Any thoughts, comments, questions, things that popped up in this chapter that you guys might specifically want to discuss so we can kind of get that list going as we start off?
Well, a little pet peeve just to kick us off here, since so at the very beginning there in that first couple of sentences, for a book that deals with legal principles, I don't like the fact that they use relocating boundaries when they talk about resurveys and that type of thing, because relocating means to be putting it in someplace else. We're reestablishing boundaries, not relocating them. I mean, it's just one of those little pet peeve type of things.
I appreciate that. I read right over that. I understand the nuance of what you're saying, but no, I appreciate you pointing that out because someone may not understand those nuances. Any other thoughts or things that popped out so we can get a list going? Otherwise, we'll just kind of go through it and jump in.
Well, that first principle is basically whenever you're dealing with remonumentation of PLSS corners is a real good example of that type of thing, is you're establishing a hierarchy of the dependence of the authority of a replacement monument based on the evidence that you use propagating the original corner. That's one of the reasons that I assume most jurisdictions, like in Wisconsin, you're required to file a tie sheet that shows all the information that explains why you accepted a position different than one that was established before, one that was accepted before, so that you build that chain of evidence into it. So I mean, that's a perfect example of that first principle. Where it gets a little bit iffier is if you're doing a property resurvey and not PLSS corner, and you come across a monument that looks like it's in the right position, but it doesn't match the original monument as far as the type or size or whatever, what authority does that monument have, and what connection does it have to perpetuating the original corner location? How was that documented?
So let's throw this out here. I know we're generally West Coast here, but we've had some people from other states. And does anyone on the call practice in a state that does not require some sort of record tie sheet, monumentation sheet, or the like?
Is anybody here from Minnesota, from Michigan? I did a presentation in Michigan many years ago, and they told me their process there was that when you filed the remonumentation form, before it was accepted for recording, it had to go through a council of other surveyors that evaluated that information to make sure that everything was up to snuff on it. So there was actually a review process that was involved with filing a remonumentation sheet. We don't have that here in Wisconsin. I don't know if any other jurisdictions do.
Yeah, like I said, Utah really doesn't have it. There is a tie sheet requirement, but it is by and large not enforced or held to, because the section corners fall under the jurisdiction of a county surveyor who should be doing that. And
Does
so,
every county have a county surveyor?
no, a lot of counties have either contract surveyors, or it's a surveyor recorder combination. And that's where it really starts falling short, because sometimes you have a surveyor that happens to be the recorder, or sometimes you have a recorder that happens to be a surveyor, or a register of deeds in Wisconsin. I know that's the term they use there.
Yeah, I'd say Nevada, we're either corner records, you can file a corner records, or you can file a record of survey, but most people pretty much do the record of survey in general, just to kind of memorialize the whole survey, right? Make that survey defendable by itself rather than just a corner record. But
every type of survey that you do in Wisconsin, whether it's an original survey, like in the form of a subdivision plat or a condominium plat or whatever, even a cemetery plat for that matter, you're required to tie to an original government corner. Same thing with any resurvey, you're supposed to tie to an original government corner. As a matter of fact, your direction has to be established off of an original quarter line or section line type of thing. So, and our remonumentation criteria under the minimum standards say that when you use a corner, if anything has changed about that corner from its last tie sheet or information, you are required to file a new monument record for it to preserve that information or to indicate what those changes are and that type of thing. So we do have a requirement to basically police or monitor the condition of the PLS corners, because we tie to them all the time.
yeah, that's nice.
And I think in Wisconsin, I know Idaho's this way, along with just monumenting that, or recording that monument or tying out that monument, there are actually tie points that are also required too.
Yeah.
I think it's 4 in Wisconsin, if I remember correctly.
Yes, yeah, 4 witness ties.
4 witness ties. And Idaho, I think, is a minimum of 3 witness ties. Which again, this monument I was looking for this afternoon had like 6 or 7 witness ties. Half the azimuths were wrong and the other distances were wrong because they were tied off a curve or something else that definitely was not in the right spot. I know the road had been widened, but I think it had been widened prior to the tie sheet. So that was the interesting part, and the challenge that our crews had. So that kind of kind of going down this thread now still, without getting too much further into the book here, I wanted to kind of continue on this thought. You know, we've found this monument, right? And like Trent said, often the practice for them is to monument that in a record of survey. So I want to throw it out to the group here. How are you documenting that monument on the record of survey? And let me give just a couple examples. Often I see found section corner, or on the other end, I see records of survey now with technology. It's actually a picture of that monument, right? Or a sketch of the monument. But at what level or how are we monumenting that what we found is actually that original one to kind of satisfy principle number one?
I would say for kind of Nevada, right? I mean, a lot of ours are in either concrete or well mons. So ours are a little more, I guess, in the metro area, right? And so you're found brass cap in well, with the LS number, all on the face of the map. Same thing, found brass cap in concrete, found out cap. All of ours will be, size and material and LS number. And then our practice, at least at our company, is to reference, what map we're accepting it via, right? Reference 4, reference 5, that kind of thing. Comes in kind of with the California play, referencing, although on record and measured for every B and D on the line in California all has a reference number on theirs, as opposed to every B and D has a reference, versus ours just references the monument itself. But then, somewhere, say, work in California, right? You're found 3/4 inch iron pipe 6 inches down, right? I mean, you want to go into that level of detail in more of the rural areas, or, traditional type thing. Found, 8 inches up, traditional, GLO brass cap, right? That's the kind of level of detail you want to put on a map, right?
Yep.
6 feet off the corner of a fence, any of those retracement type things that we're trying to talk about in as much as you can to retrace that point so somebody can find it, even like in your instance, right? You just said that section corner was 12 months ago, somebody located it, but the tie sheets and stuff that were provided didn't even get you within a ballpark. So
right, and all the survey I was going off of said found section corner flush with asphalt.
Mm-hmm.
Which indicates to me it's in the street, but they had overlaid the street with just tar, right? Yeah. So I walked the street, I buzzed it up and down 20 feet each direction where I thought it could be, but again, so much else was wrong. And if they had said does not match tie sheet, or not, right, there's a lot that could have gone in there if they had reported back to the county that, hey, county, this section corner does not match the tie sheet. We could have found it, right? It's very easily for that one to start moving towards the lost position if we don't do something like that.
And that's something I like with Indiana, right? Their survey report or their survey narrative all on the cover of the map. I wish, and even coming from Nevada, we don't require it. I wish there was more states that did require that, because I think it's so beneficial for following behind everything later. I love that.
Yeah.
And I think it's something you're kind of working on in California, right, David? They're trying to put something like that into play.
They're trying.
Yeah.
But we've had very little success with that.
Yeah. I know it's an uphill battle.
But yeah. I mean, it's just like I'm looking at this record survey right now, and I'm trying to figure out what this guy did. And
yeah.
Report would have been great to have.
Right. But, yeah.
Yep.
Yeah. I have one of the monument notes right in front of me that I'm about to put on my record of survey. So I'm saying found 1.5 inch iron pipe tag ... 2507 ... because it's not completely legible, down 0.4 feet, north 49 2123 west 0.36 from line, accepted as 1.5 IP, no reference, 0.29 feet westerly of line per such and such map, parenthesis record 4. not found 2-inch iron pipe tag RC 29356 per PM, blah, blah, blah. Basically because there's a question about several different underlying maps are showing me the monument kind of keeps changing in character, and I'm not sure whether people were just sloppy measuring that 2-inch iron pipe inside versus outside diameter and eyeballing it. And one guy calls it 1.5-inch pipe, the other guy calls it 2-inch pipe. And I also have an issue with two different LS numbers. So I put all of that in the description and explained exactly what it is that I found and the disposition of that monument with respect to the line, because also I have several maps showing that monument in a different position off the line. So the whole thing is kind of dancing around the location. So since I've gone through about 4 or 5 maps that have all surveyed through that monument, I documented the whole history of what I found has been happening with that monument throughout the maps.
Nice.
You know, one of the things I do in cases like that is in my narrative, you know, I'll put my, I'm OCD. I'm very habitual in things. Like we've got our title block on the far right side. I've got my vicinity map right there, and always right under that is where I always try and fit all my information. And so I'll get my survey certificate and then my narrative. And I always said, you know, reference as part of this survey are surveys. This is the information that I've gleaned from that I've used in particular for those. Looks like we've got a question from Matthew.
Yeah, go for it.
Yeah, hi. Sorry, you might have covered this already. I had to help somebody real quick, and I came back about 5 minutes ago. But two surveyors just mentioned something that's core to me that I've been waiting for an opportunity to bring up in this chapter, and that is pointing out what you didn't find is just as important as pointing out what you did find. And I find that lacking on a lot of maps, but it's really informative to know if they searched for something and didn't find it. I think that's as much evidence as searching for something and actually finding it. Because I always wonder, well, I wonder if they searched for this pipe over here when they don't tell you if they did or did not. You know, still due diligence, I'll go search for that pipe myself, even if they show it to search for not found. But I think just tracking that throughout the maps helps that pedigree and helps us understand what's been looked for and not looked for.
That's great, Matt, because that's part of the problem that I have with all the corner records that I'm looking at down here in Orange County is trying to get people to say, what were you looking for? What did you, it goes out, well, search found nothing. Well, what were you looking for? Would you look for the pipe that was there? Did you look for the spike and washer that was there? I got 3 other corner records that say there were 3 different types of monuments out there. And I get so much pushback on that. We do not want to do that. No one wants to say, put their foot out there, put their head out there and say, what did you look for? No, no. Why do I have to do that? Why should I be bothered to have to tell you what I'm looking for? So yeah, that'd be great. Love to see more of that.
Yeah.
Well, let me bring that a little closer to home too. My wife asked me to go look for something, and I do go look for it, but I never want to admit to her that I was the idiot that didn't find it, because that next surveyor does come out and he's, you know, I did a survey in Iowa, and it was like 5 hours from my office, and I drove out there 3 or 4 times to find one section corner that everything was tied to. And it was on this fence line. Highway's here, and this fence line comes north off the highway. And it was a right-of-way marker, it was a property corner, and it was a section corner. It was all in one monument. And I needed it. I went out there 3 or 4 times to go do other stuff on the property, and every time I went out there, I kept searching for that stupid monument. And my last trip out there, I tripped on the thing. I had been through that area, like I said, 3 or 4 times. And the last time, I'm like, okay, if I don't find it now, I'm going to give up, and I've got to find some other evidence. And I trip on this stupid thing. I'm like, how did I miss this every single time? You know, and so I don't want to be that survey that says I have decided the corner was here, or this is how I've determined the property here because I didn't find this. And then someone else goes out and finds it, and it makes it look, I mean, it's a pride thing, but it makes it look like I did not do my due diligence to find a corner. So I understand that reluctance to say this is what I didn't find. I go through the same things for the crews, right? They don't find a corner, but they don't put in their field notes searched or buzzed or didn't find it, or they didn't shoot other evidence in the area, right? A fence corner or something like that. They left it alone because they didn't find anything, and there's no points on in their point file, and I don't know what they did. Did you guys even go out? They walked past it, you know. We've got quite a bit going on in the chat here, and I apologize to Justice. I've ignored you just a little bit, but I did see your comment here. So in Florida, they fill out an affidavit for section corners if it was found in the right place. And John asked, what if it's not in the right, or Jerry asked if it was, what if it's not in the right place? And Justice responds, it's more of a relative science. It will largely depend on tolerance limits. John Stahl jumped in here. Welcome, John. They're never in the right place. Once found, the evidence to prove the monument isn't found in the math. And then Brian asked a question about pipes as property corners. Do most surveyors call out outside diameter or inside diameter? My understanding is inside diameter, since that is how pipes are measured for plumbing and draining purposes.
Yep.
We don't use pipes in Utah, so I can't answer this one.
You don't use pipes in Utah?
We use rebar.
Huh.
3/4 inch rebar, number 6 rebar that they call it. So it's the general acceptance.
Same for Nevada.
Yeah.
Inside diameter. That's how they're made. Yep.
Well, it depends, because there's a nominal, and the nominal doesn't match the inside or the outside diameter. So it's sort of like dimensional lumber and that type of thing. 2x4 is not really 2x4. So it's in Wisconsin, what we do is we give not only the nominal diameter, but we also give the weight per foot as well as the length of the monument. So that gives you additional information about the physical characteristics of the thing.
Our good surveyors like Connie, she'll put on their inside diameter or outside diameter. She'll tell us which diameter she's measuring.
Yeah, I mean, usually it's the really nominal. It's either a 1 inch pipe or a 2 inch pipe. So we want to know for the identification purposes. For example, when I had this pipe that says it's 1.5 inch iron pipe. So now I'm trying to figure out, okay, is this the same pipe that was originally set and somebody retagged it, or is this the pipe that somebody completely replaced the pipe, or am I finding something in the wrong place because this pipe, different people are finding it half a foot away, and I had my guys dig pretty sizable hole to make sure that they didn't find another pipe in there. So I don't like these in between pipe sizes, because you will, you never know what people have measured. I tell my guys, measure the outside diameter, make note that's what you measured, because there's rules, or not really rules, but custom in California is that your lot corners are usually marked, monumented with a 1 inch iron pipe. The tracked corners, road intersections are often monumented with a 2 inch iron pipe. There's seldom, maybe in the older days, that people were actually using a 1.5 inch pipe, or sometimes you get a 1 3/4 inch pipe. And really, I don't care about the specific measurement of the pipe. I care about a measurement that's close enough so that I can say with a level of certainty that I'm looking at the same pipe.
And I take it one step back, and maybe I understand where you're looking at pipes and you want some consistency in there. The standard is a 3/4 inch rebar, 2 feet long in Utah. but there's two things I don't call out. I don't call it found 2-foot rebar with plastic cap stamped, whatever, because I'm not digging up that rebar to find out. But I see that on surveyors, right? Found 2-foot rebar with cap. I don't know how, they could have said a 1-foot rebar for all I know if you dig down far enough. And then I don't generally call out the diameter of the rebar because it's generally known, and I try and identify it by the cap first. That's the critical one for me. If it has no cap and it's obviously a different size rebar, and sometimes we do find pipe, I will mention that as the anomaly, not the standard call. Okay.
You guys set rebar, do you leave it sitting above ground or do you set it flush?
It depends on the area. If it's a rural area, up against like a fence post or something, I usually set it a little high so it's a little bit more visible in brush and weeds. If it's a more urban area or an area with livestock that might be trampling it, it's not on a fence line. Definitely in a lawn, I try and set it flush or maybe just a little bit lower so it doesn't get hit by a lawnmower or something like that or tripped on.
Yeah.
Okay, great discussion. Any other questions, kind of comments along this thread? Trent, if you'll move down, just put that whole image in our screen there for us. The book talks about perception. This image used,
which is what we just got done talking about. Perception of a pipe size.
Yep. So many of us have probably seen this already, right? But in here you can see like a goblet or a chalice in the center, or in the black space you see two faces looking at each other, and so we need to talk about what we see, what we find, the perception of that, and gather all the evidence so that we can clearly see the whole picture and the intent of that. 10.2 talks about vanishing evidence. I think one of the hardest things that we have as surveyors, I'll go back to my section corner here, the vanishing evidence. So if I look at chain of events over that section corner, I know, because I lived right in that area. I grew up just down the street from where the section corner was. I personally, talking about last time's class, the history, right? I know that road has been widened. I have no doubt that it has. Question was timing on that widening, whether it was widened before or after the tie sheet and things like that. I'm not quite clear on that, but I'm pretty sure it was widened before the tie sheet, the current tie sheet was drawn up. But things like vanishing evidence, your blazes on a tree or anything like that, those get lost over time, and so that evidence is harder and harder to find. But the description in the field notes are critical. How learning the lessons of the past, our field notes and our surveys being as precise and clear and explain as much as we can helps to alleviate some of the issues of time and vanishing evidence. Years from date of creation of evidence, percent of evidence recovered, just an interesting chart there for what it's worth. Principle 1, now jumping into the book here. I want to read just a few of these kind of points to help us continue this discussion. But under Principle 1, it's got a little box there. Retracing surveyor should never give up hope of recovering original evidence. I know many of our speakers and our known people in the survey industry, a corner never really is lost, right? There's always some sort of evidence to find. And the older this country gets, I think the more true that, my light just went off there, the more true that might actually be, because it's going to have been surveyed at some point, through time. And so you can use those surveys to help kind of establish that, right?
I love John's comments in the chat. Search for the monument until you find it, or explain what happened to it.
Thanks, John. I like that too.
Yep.
but I think the important one is this 10.3, talking about the degree of proof. Proof is not evidence. It is only the effect of evidence. It is the establishment of a fact by the evidence presented by a party. Proof is any evidence that is presented to make a fact more probable than not. Proof is the effect of evidence. While evidence is the medium or nexus to get to proof, some legal scholars say that proof is the perfection of evidence. For without evidence, there is no proof. The law recognizes 3 degrees of proof in order of evidence needed to prove the fact. 1, positive proof, also called preponderance, creditable or substantial. 2, clear and convincing, reserved for property rights. And 3, beyond a reasonable doubt, applied to criminal complaints. Again, I kind of talked about this. I got sucked in some court cases over the weekend, just on TV, YouTube. I had a whole blast thinking about the preponderance of evidence, the proof of evidence, what is fact, how do you determine fact, the jury's role. I went down a huge rabbit hole this weekend with this, but those that might be more familiar with court cases as they involve surveyed boundaries, I'd love to hear your thoughts on those 3 kind of levels of proof there, and how they apply or don't apply to surveys. Anyone care to share?
I'll jump in.
Okay, thanks, John.
With boundary evidence, it's the lowest form of evidence required because otherwise you would never be able to prove the boundary. You never know where the boundary was. You wouldn't have enough evidence to meet the standards. So it's the lowest, and usually was referred to as the preponderance of evidence. Evidence that says, yeah, it's most likely this and not anything else. And that's the presumption. It's all based on presumptions. The clear and convincing standard is used for title matters, when you're proving ownership of property and that kind of stuff. Who owns a piece of property? It's a clear and convincing evidence. That's because there's a higher standard there because of the statute of frauds saying that all the transfers of property have to be done in writing, and there has to be some passage of evidence there that defines that, or that will signify that transfer. The beyond a reasonable doubt standard is from criminal law, and hopefully we don't ever have to go there. And it just doesn't have any application in boundary law at all.
Thank you, John. I appreciate that. Any questions about degree of proof needed? I think this is, if we circle back to past weeks, this is always the one that we've struggled with in our discussions. When is enough enough? And John kind of said it, right? Search for the monument until you find it, or explain what happened to it. But I know that's our hardest thing as surveyors, is when do we have enough evidence to find a narrative of what happened to it, whether it be a monument or a property corner or property line. And I've always said sometimes you just kind of have to pull the trigger, right? But this really helps. Think about if you had to defend your survey, what degree of proof do you have? Do you have reasonable enough proof that what you've done is correct, and is it defendable? Do your notes, do your field notes, does your survey, does your narrative, you name it, have enough evidence that any reasonable surveyor would then go behind you and say, oh, I see how they got there. I disagree, but I see how they got to that point, right? And so I think that having that understanding of the degree of proof needed for a boundary really helps kind of calm my anxiety about surveys and being able to then push forward. Go ahead, John.
Yeah, and one thing I'd like to point out too is that most of the time I find ourselves we find a monument and then we want to prove where it came from and where and try and find all the evidence to substantiate the monument, which is the correct thing to do. But we too often look at that as the way to prove that I can accept the monument, when in fact
the rules of law are the presumption of the found monument is that it is correct. It was intended to mark the boundary. It was, it has all of the intent of the landowners behind it because it's there. And so when you find it, the proof that you have to, if you can't find enough proof to know where it is, the question then falls to, well, can I prove, do I have enough proof to overcome the presumption of its correctness? And the correctness can't be overcome by measurements. It's not a question of, is it in the right spot? It's a question of, has it been relied upon by the landowners? Has it, who's done what based on this monument? And so we flip that script often in our heads and want to, we're hesitant to accept a monument until we can prove where it came from and know what its history is, when oftentimes the history and that knowledge is lost to time, and it's unrecoverable. But that doesn't mean we can't accept it. The presumption is that we have to accept it unless we have enough evidence to overcome it.
But it's seldom that we're evaluating one monument at a time. We end up with a whole system of monuments, and the times you're evaluating and doubting certain monuments is when they're in conflict with the rest of the evidence. So if if you have a monument that's not original, not necessarily, you can't really tell whether it's been relied upon or not, and it doesn't fit the rest of the evidence that you have for that project, then just the fact that the monument exists doesn't necessarily mean that it's representative of where that boundary was originally intended to be. And a more practical example would be, sometimes you do get surveyors that are setting monuments in haste on incomplete boundaries, and they think they decided where a certain corner is going to be. They set the monument, and you come 15 years later going, there's a monument, but what the heck did this guy do? It doesn't fit anything else. I'm not going to accept it. And of course, if it's, you have additional evidence, if it's been relied upon, if somebody has built something, lines of occupation are all of a sudden fitting. But so there's almost always additional evidence, at least in like urban, semi-urban, and relatively dense rural areas, as opposed to just thousands of acres of open land. So there's different approaches to different areas.
Yeah, I find, just in my own mind, when I'm reviewing monuments or property corners, I know we need to be careful with the language we use, so we're clear on this. I always off the bat have an easier time recognizing a monument as correct with very little effort. I generally have a harder time recognizing a property corner as correct without some sort of review and verification process through my survey, the gathering of evidence. But I understand that isn't necessarily correct. I mean, it's proper procedure to grab and evaluate all that evidence, but by the same monument, if it is the original, same token, if it is the original property corner, right, it still has those same legal protections there as set and occupied by the original surveyor and landowners.
Yes, the original monuments, yes.
Yeah. Again, separating the difference between section corner monumentation versus property corner monumentation. It's a mind thing for me, but go ahead, John.
Yeah, I think we oftentimes get a little bit confused in the way the courts look at a monument and a property corner. In order for it to, we use the term monument, that implies that it is a physical marker intended to represent the property corner, the corner location.
Yeah.
And when it's set, that is the intent. Even if somebody paid a surveyor to slough it in there and do a crappy job, the owner still paid a professional to go in there and set the corner, intending to have his corner marked. So he's paid good money for it. He's done everything he should do in order to establish the location of that corner. So that's why the presumptions fall on that monument, is because it's there with the intent of marking the corner. Now, if it's just a piece of junk that was never intended to mark a corner, that arose from whatever, the goat stake, the proverbial goat stake, where I don't know if I've ever found one of those, but that wasn't intended to mark the corner, then it's not a monument. So we don't have a monument to accept, and there's no presumptions that are tied to it.
Well, to a degree, unless that monument that was intended to be set at a time it was set is in conflict with somebody's senior rights existing in the area.
Oh, it's usually always in conflict with something to some degree. The questions, though, become then, I think we spend too much time comparing ourselves to ourselves as the test of, do I accept or do I reject? Oh, this surveyor I can measure better, or he doesn't measure so well, or he sloughed it in, or he blundered it. And we try and test ourselves against ourselves, when the real test of accepting the monument has nothing to do with what the surveyor did at the time. It has to do with what happened after the surveyor left. The landowner paid good money to put that marker in the ground. Why? So he could build a fence, so he could build his house, so he could make improvements to his property or do whatever. Was that knowledge of that monument passed on to subsequent owners? All that kind of evidence starts to come up. But that's the evidence of reliance that we have to look at. And it's not a subjective reliance. What did the landowner think about this corner? It's an objective reliance. What did they do? And when they do things, it results in physical evidence of these improvements and other things. And so we don't have to even have the people present to figure out, oh, there's monuments, there's a ditch here, there's an occupation line there's other survey markers here and there. And all of that evidence is objective evidence that proves what the landowners did, and what they did is the best evidence of what they intended to do.
I have a case right now on a record of survey where I have two lots that are approximately 160-ish, some odd feet wide. And one of the owners about 7 or 8 years ago had his property monumented 7 feet into the other guy's property. And now they're disputing. That monument is not being accepted as indicative of their property corners, even though it was set by a surveyor thinking that one of the owners, they misinterpreted something from the original deeds. And they extended their property, they built the fences, eventually the neighbor caught on, and now they're in dispute. And the guy that set the monument 7 feet away from where it needs to be is not in a very defensible position, nor is anybody else that's accepting the monument. They're accepting it as this is where the guy thought it was at a time, but that's not, it was never indicative of the title.
Yeah, you raise a good point there, because not every monument that's set on the ground is intended to, or marks the corner. And when you've got a conflict between two choices of two monuments, or two boundary locations, well, they'd be two monuments of some sort. But anytime you've got that choice between the two, now you're going to a different level of standards of practice, or standards of care, or different level of even legal principles to prove, well, which one is the correct one and why. And there you're talking more of a negligence claim against the surveyor to come out and fix the fence problem and fix his survey. So you're not even, now we're not talking really about boundary law issues so much unless you're, except for to prove the negligence. I mean, the duty, the standard of care, breach of standard and that stuff. But yeah, you end up in a more of a negligence case issue then, because the guy can't defend the survey or can't defend his monument. And yeah, you can't blindly accept all the monuments, but so everything has to be tested. But we have to be careful on the perspective that we have on what we're actually testing and what the reason for the test is.
Yeah, no, I'm not talking monuments that don't fit the math by a few tenths or even half a foot.
Yeah.
If the monument has been set, you hold the monument unless you can prove that there's some kind of an error, like what we're just talking about, a more serious error.
Yeah, and even then, sometimes if the landowners have relied upon it,
yeah,
in certain ways, it may be too late to fix them, and then it's just purely a negligence issue.
mm-hmm.
What are the damages caused by the monument being set improperly?
Yeah.
And what I say is, welcome to week 93 of Mentoring Mondays, Conflict Resolution Part 1B.
Right.
Part 2 will be November 7th.
Yeah.
We had this great conversation, similar to kind of what we're talking about right now. What John led the discussion on Monday, similar to exactly what we're talking about right now, which is just fantastic conversation. It's good.
It carries over well into this topic, well, into
Absolutely.
the book, right? But
Absolutely.
So Justice asked, which criteria do you use to accept or reject monuments? Do you perform a comparison sketch on all the found monuments to see if there are inconsistencies? Someone else want to jump in there? We kind of talked about that a little bit, but let's make sure we have a full understanding of the degree of proof needed. And
I think that's the rub right there of being a boundary surveyor, is trying to find that line, that gray area. And to John and Bonnie's point, I mean, they're both on kind of pulling two different ways in their discussions, but I think we're always wrestling with that as boundary surveyors. We had one where we could show the original surveyor or the retracing surveyor had set something 200 feet in the wrong spot, and we showed it and it had harmed our client, but it was so old that the courts said, yeah, the surveyor was negligent, but the monument's going to hold, and so, a big lesson was taken from that. And I'm wondering, like, at what point do you hold the monument and what point do you not, based on, I guess, that common rapport or people have been using it, and how you figure out how many people have used that. And did our client have that opportunity or even know that this corner had been set back in the day? They could have disputed, but they didn't even know at the time. So, it's almost like this quasi judicial role we have, that we're trying to figure out where that line is. And sometimes I feel like it just has to go to the courts to be decided. And, we can show them this is where it should have been. This is where it was, this surveyor placed it, and it appears everybody's been using that. But as a surveyor, where do I put my chips? I'm open to suggestions on that. I really think that is the rub of being a boundary surveyor. We're constantly in that conflict.
I have a project that I'm working on right now. It's just a simple little parcel, kind of triangular trapezoidal parcel. I found 6 monuments, and at first I thought it was going to be easy. I ended up going through 18 maps and 7 deeds to document everything pretty much from the beginning, because it relies on the descriptions start based off of a rancho line and intersection of the public lanes with a rancho, and then I had to track down and link all the evidence from when that rancho was established to how Caltrans treated it, how subsequent subdivisions treated it, how cities perpetuated the monuments in the area, and who's reset the monuments in subdivisions next door. So I had to track all of that down before I could really make sense of out of the history and how the whole area developed to decide. And I ultimately decided to survey just one side of the right of way of the freeway, because there are two non-parallel lines that are controlling. One is controlling the east side of the freeway, one is controlling the west side of the freeway. Anyway, it got complicated. The short story is, you dig to the beginning. If you have that evidence, you go to the beginning and you try to make sure that all the links in a chain are connected. And if they're not connected, then it's up to you to make a decision. Does the disconnect fit? Can I, with a reasonable certainty, say, well, even though I don't have a link in history between a couple of events, are they really perpetuating one another? Can I continue on the same path, or do I need to look and see what's happened during that blank period? If something different happened. So you kind of like research the entire history of the area before you can hang your hat on it, in order to arrive to the conclusions. And sometimes you get to a point where you possibly could have a couple of conclusions and they're competing for interest, and this is where that preponderance and evidence comes into play. I've never gone as far as having to actually make a list to see which evidence is going to pull in what direction. Eventually, usually when I'm close to the end, it crystallizes, but sometimes it's a pretty close call about what you do, whether you shift things a little bit in one or the other direction. So anyway, so that whole description was a 4-day process to look through everything.
And this is where your survey narrative comes into play to explain how you did it and why you did it.
Yep. Yep.
Great discussion, guys. I think just to kind of wrap up a lot of what we're saying here, and to answer Justice's question, or to make things clear, easy for everybody, purpose of the book. So according to the book here, the clear and convincing is kind of that level. That's what's reserved for property rights, right? We need to have an understanding. But we've talked about this in past chapters, right? We get to a point where we've gathered as much evidence as we feel that we can gather, right? We're running out of new evidence to get. And so you kind of have two options at that point. Either you have enough evidence then to make your case. It's clear and convincing to you, to a colleague, to your company, to lawyer, to the, whoever you might be talking to with that. Hopefully you've got someone to run ideas past, right? But even if it's just yourself, one-man band outfit, is it clear and convincing that the evidence you have demonstrates that this is the most likely place for that property be placed on the ground, right? Or the second thing that happens is you just do not get there, right? You have exhausted all efforts. You perhaps have, and this is a harder part, exhausted your contract, right? So you've got to go back to the client and say, this is where I'm at, open and honest. We cannot make it a determination because of A, B, C, and D facts, right? This is just not somewhere we can take the leap to, can I spend more money to keep tracking this down, or are there other avenues, and the book talks about oaths and witness evidence, talking to neighbors, is there other things you could do outside of that, and so then it's up to the landowners looking for the answer, right? At what level do they want to invest to get into this? So, Justice, it's that clear and convincing, or it's, we've got to stop work, and our contract clauses allow that to say, okay, we're stopping here. What's next, right? How do we solve this? How do we work together to solve this? Going through here, I'm glad this has taken longer. We're already at over 6 o'clock because I was worried about this chapter. This is great. Thank you so much, guys. I'm going to hit just a couple of the kind of the header points through here, I guess, to kind of just reiterate what's in here. The book talks about the authority and the responsibility for perpetuating evidence. So the surveyor is delegated, if the surveyor is delegated the privilege of remonumenting or remonumentation of deteriorated corners, he or she should also be delegated the responsibility of perpetuating the evidence, right? So if we go out and do a property survey and those corners are deteriorated, and we've got to do it, we also have the responsibility then to monument how it. The beginning of the discussion here, that field monumentation, what do our field crews do to help us do it out? And our office monumentation, the face of that survey, and how do we explain all that? Setting corners on the ground. This is where we get into every state has some different kind of level, right? We talked about the general use of pipes in California, in where Trent and I work, Utah, Arizona, Nevada, Idaho, it's rebars and caps, I think Jerry jumped off, but I think Wisconsin law says, theirs doesn't specifically call out like a 3/4 inch rebar. I think their language has something along the lines of durable and permanent in their statutes for property corners. And so what does that mean in that state, right? What does it mean in the states you guys are working in? Don't want to read through that. So then at 10.7, oaths and witness evidence, identifying marks on lines and monuments, and recording documents. And that's the other thing I wanted to spend some time going. So, I think at this point, most, if not all states, I can't think of one I'm aware of, require some sort of filing of surveys. Is anyone aware of any states that don't require a filing of a survey? We still have private surveys that hang out with the companies.
I was gonna say,
Go ahead, John.
Yeah.
Yeah, back east, there are a lot of states that don't. As you get more and more in the western states, where we're only 100 years old, we've wised up enough to, I think, get most of the filing acts. Texas still doesn't have a filing act. But a lot of the states east of the Mississippi don't have them. They just never set them up, especially the original 13 colonies. They don't, most of those don't have them, and they all have their own in-house records that they share, but there's no indication on monuments as to who set them. And so you never know who to go to, but if you got a difficult survey, you just check with some of the other surveyors around town and see if they've got any records. And they all have their own little repositories, but no filing act at all. So no public repository at all, which makes it very difficult for them to perpetuate survey evidence. I mean, it's just about impossible. I think Texas probably comes as close as any of them to being able to perpetuate evidence without having a filing act. And that's because they do what they call their field notes, which is actually the legal description of the property that's included on the deed. There they call them their field notes, because they'll go do a survey and then they'll basically write a record measured as-built description of their survey, and they go on and on and on to describe the monuments found and points along the line, and pages and pages some of these legal descriptions are, or field notes are, that are attached as the legal description for the conveyance document. And so they're basically taking that picture and turning it into 10,000 words, putting it in a deed, and perpetuating the survey evidence in through the title record. Most states don't allow that because you're reforming the deed, which is illegal. You can only reform a deed in certain very limited circumstances, and they do it carte blanche. It's just standard of practice for them.
Interesting. So we got Marion says Virginia for one, and Brian says Ohio and Kentucky, or at least the counties they work in. I will not allow you to file a survey unless property is transferred. So yeah, I wasn't aware of any states. Obviously, I'm a West Coast boy, but I would have thought or hoped at least those states would have wised up at some point, would have started a point from here on out. That, but I imagine then Brian, Marion, our surveyors work together better back there. That there's more inter-surveyor communication and kind of collaboration to help with that. Or is it like some of these West states that, oh, you can go pull my survey and that's about all you're going to get from me?
So I don't actually know. I'm still in college and kind of learning the ropes, but for my boundary location class last semester, we had to do a project where we picked a parcel at random that kind of looked like it might have issues with the boundary to research. And the one I picked just so happened to have been transferred by will for so long and had not had an updated legal description since the early 1800s. So and it was a remainder from a lot of other conveyances. So I had to rely heavily on that whole concept of the preponderance of the evidence. So that's where I make the presumption that Virginia does not necessarily require updated surveys, because I did find indications that like the whole property had been surveyed before, especially with some of those conveyances for the adjoiners, but the only part of that survey that was recorded was for those adjoiners, if that makes sense.
Yeah, no, thank you. Brian says that the company he works for has a huge library of data from over the last 165 years his company's been in existence, and many other surveyors come to them for information. David says, my experience in Texas, you go with your hat in your hand to your neighbors or their survey and ask for a copy of the prior surveyor. It usually works out. Many surveyors won't humble themselves to do that, though. You know, that's the hard part, you know. In California, it does the same thing. There are plenty of unfiled surveys in California despite the filing requirement. I'm finding Utah, so the county I work in, we've talked about this in the past. So Utah requires a record of survey to be filed when you set property corners, and before doing like a subdivision plat. County I work in considers that subdivision plat to be a record of survey, which is a little bit backwards considering the explanation we've given of the recorder's office and the surveyor's office being separate, and the purpose of a survey being filed in Utah is just an offering of an opinion for other surveyors to look at, but has no real legal effect on the boundary itself or deeds and title. You know, but we get some of the more rural counties where there's not that enforcement of it, and you see less and less surveys being filed to go hand in hand with a plat, you know, an original survey. So we see it kind of all over too. There's those that do and those that don't. Okay, well, thank you for that discussion. Coming back through here, 1011, use of aerial and terrestrial photographs to preserve evidence. This is where I think our new technology really comes into play. I know a lot of companies that now every survey or every crew has a small drone, right? And they just throw that drone up, quickly fly the property in a few minutes on a boundary survey and record that evidence, right? And back up their survey. I knew of a company out here that when scanners were getting big and they were trying to get their crews going with the scanner, they would quickly, you know, do the loop around a small lot survey with the scanner. They wouldn't do anything with the data unless they had to, but they used that as a way to preserve evidence. That first paragraph that Trent's highlighting, an ancient Chinese philosopher once said, "A picture is worth 10,000 words." We can paraphrase this saying, a picture or a photograph in the hands of a qualified expert is worth 10,000 words. But like all other evidence, if it is misused, it is worthless. But in the proper hands, it is valuable as evidence. I've seen some really great tie sheets that have a picture of the monument. Weber County here in Utah, all their tie sheets have an aerial image of the section corner location, so you can see fences or other terrestrial landmarks, within 100 feet or so of that monument, 200 feet of the monument. But then they've got a second sheet or third sheet that you're standing in front of the monument looking north. That's what that section corner looks like: north, south, east, and west. They dig a big hole. If it's in a hole, this is what that monument looks like in the hole. Those are the great ones. You want to talk about preserving evidence. Those are the ones you don't even have to have your GPS on. You can go walk straight to them because you know exactly where that monument is. And that's harder to do on the face of a survey where it's going to be copied, it's going to be printed on Mylar perhaps. How do you portray those images? And so how can we, either through our words or descriptions or graphical depictions, give that same amount of evidence so it's clear where you're tying to or setting or tying from. It talks about use of old photographs, riparian evidence. 2 or 3 weeks, 4 weeks ago now, John helped out when we were talking about riparian boundaries, and he went through some really cool old images, right? Preserving that evidence, having a repository for that so that we can go through some of those old boundaries. That's exactly what this book is talking about, being able to look at it over time and the change of that, or what did it look like originally and what was the use of that is really pretty cool. Daily use of preservation of evidence and video. Here's an interesting one. Let's jump over to 1015. Jumping through a bunch of really cool stuff, but want to touch about this one. Preservation by state plane coordinates. We talked about this a little bit last week when we talked about the history of PLSS and state plane coordinates. I gave the example of a city that they wanted me to put state plane coordinates on the face of my plat, and I flat out refused to. I got into it with the city surveyor just a little bit on that. But when we've talked about the rules of construction, right, and the reviewing evidence, those coordinates are obviously the lowest, but there can be a use for the preservation of those coordinates. On our tie sheets, they're state plane coordinates. I use those not to just plug it into my survey and go say I tied to this corner because I've got a county published coordinate on that monument, but it can help me get close, right? But we can preserve things through referencing monuments. Second to last paragraph on this one, it says surveyors who utilize state plane coordinates must understand basic control surveying. Each basic control monument is subject to some error of measurement and adjustment. The land surveyor must identify the monuments from which his or her coordinates were calculated so that subsequent surveyor who wants to follow in the footsteps may duplicate not only the work, but the inherent error as well. I see this a lot more in construction surveying than boundary surveying, but someone that does not understand ground versus grid and what coordinates they're providing, or a state plane survey or a modified state plane survey that might have some sort of rotation, or following behind the DOT who does a truncated state plane coordinate, right? So their coordinates are published the last 4 digits, so they're a lot smaller. So their sheets aren't as big. But there's a lot in the art of surveying, I'd say in the geomatics portion of surveying, that this section covers of understanding how that GPS works, what is behind those state plane coordinates and how they work. Without question, if a state plane coordinate system were accurately established with a high density of monument locations and all surveys, including resurveys, were tied to it, an ideal system to perpetuate evidence would exist. But until such time as the public appropriates sufficient funds to provide for the density of monuments needed in the net, the property surveyor will continue with local monument control. In the matter of new land divisions, the public can regulate how new land divisions will be surveyed, and it is within the public's power to require state plane coordinate data. And that takes us to the end of the chapter, really.
I'm looking forward to the LDPs once we kind of roll out the next thing, right? I mean, some of these grid to ground issues hopefully will go away. It's still going to exist for many years, right? Just because we're going to be following behind all that stuff for a long time. But the LDPs moving forward, I think, might help quite a bit.
I think it'd be great. I wish Jerry was still on the call. It looks like he had to drop off, but
Yeah.
Wisconsin has had an LDT coordinate system. So each of their counties have an established coordinate system by the DOT, which are basically low distortion systems. But you get into this idea of preservation by state plane coordinates, and there are surveyors that have county published coordinates on section corners or monuments, or even a survey, and they don't go out and relocate that monument, right? They just, here it is, someone's given it to me, and I go. And there is reason for concern and pause. I think it's great. It'll be wonderful for surveying. Above my pay grade, but the company I work for and our owner surveyors, we still do 5,000, and there's a lot of reasons for that. And we haven't had the discussion with new coordinate systems coming out if we'd ever consider changing that, but I've just been told flat out that's a no-go. We'll always do that because they have testified in lawsuits where someone didn't understand US survey feet versus international feet in their GPS system, right? And they set something 30 feet off because it was set up wrong, and they just used state plane coordinates and ran with it, and then we had to go retrace that and be part of lawsuits, right? And that's a difficult thing, not understanding. And I'll knock the older surveyors, right? They know it works, but sometimes they don't know why it works. And then our really young surveyors that have always just grown up with GPS too. It's always worked, so why go with it? And you always have to check and verify.
Good
There's
stuff.
that. With the last couple minutes, I want to put a plug. I did this last time we met, but I'm going to do it here. Utah is putting on a field forum. In fact, let me pull this up real fast.
I just signed up 14 of them today.
I heard that. Thank you, Trent. I appreciate that.
Yeah.
I should have had this ready.
It's Thursday, November 17th.
Yeah. Can I share, Trent?
Yep. Give me 2 seconds. I can stop, and then you can share. And go.
Okay.
Yeah, good point in the chat there, Brian. There is some, like here in Las Vegas Valley, we have a LDP that was generated by the city of Las Vegas that we use here locally. So LDPs are definitely getting to be a little more common, but check your TBC for some of those. Go for it.
Yep. So this is kind of our flyer, Trent. Maybe I'll send this to you if you wouldn't mind sending this out to those
I will, yeah.
Mondays. I know you usually call out these cool things. This is going to be a really cool one. It is geared completely towards field crews in the CST. In Utah, as we've talked about it, we have our spring conference, which is geared towards continuing ed and our licensed surveyors. And we're really trying to raise up the level of our non-licensed surveyors, our crews, and we're reaching out and working with a lot of our major construction companies in the area that have staff surveyors that know nothing about actual surveying. And so we're going to cover each of the 4 CST levels and try and help kind of bridge the gap there, push more into licensure and understand some of the tools that they have at their fingertips that they don't. I've shared in this forum before a crew of mine that we were just doing out some surveying, and they had to calculate something and didn't have all the calcs right there in their collector. I said, you can just do a distance, turn, bearing, and angle thing, and we pull out the Kogo and show him how to do it. And he had no clue. He's been surveying for 10 years, but has always just been provided what he needs. So we're going to go through some of those background tools that are more experienced surveyors, they always just did it, right? Distance offset, vertical angle offset type of stuff that's in there. So we're going to go over the CST1, role of the survey technician. We're going to go over field books, field notes, and construction plan reading. CST2, survey math computations, equipment tips and capabilities, and interfacing with the office. The CST3, the role of the crew chief, communication, construction principles, and then the CST4, engineering principles in land survey and training, NCS test prep. And the guy that's putting that on is just about to get licensed and has some cool experience and stories to share. So I'm really excited about this one. I think it's like $30 per person to sign up. It's really not bad, but I think all that money goes back into our foundation too. So this is a great one. If you got field crews that could benefit from a little extra training, it's only 4 hours. And it'll be great. It'll be great.
I'll be blasting it out this week as well, and then I'll blast it out as we get closer to. So
perfect. Yeah, I'll send you the actual flyer. I appreciate that, Trent. I appreciate you guys. This has been great discussion. Yep. Any other questions or anything like that?
I think I'll have my husband sign up for this seminar.
Yeah, it's all online, right? I mean, it's
all virtual. It's going to be great. And then what we're going to do is as this one kicks off, we'll actually publish last year's on our website, so you can view that one, which was a similar one, covering some of the similar topics, but some other ones Trent presented last year. And so that's what we're going to do is we'll just make that one then free to everybody.
That's cool.
Yeah, cool stuff coming.
Awesome. I'll share it as much as I can.
A wonderful session today.
Yeah, of course.
Yeah, thanks, guys. Thanks for your participation.
We made it all the way to 5:30.
Yep.
Off mentoring Mondays is off for Halloween. Everybody's trick or treating anyway, or hanging out with their kids, or doing whatever. So we just skipped Halloween, and then John Stahl is back for part 2 of conflict resolution on Monday the 7th, and then we're back here Wednesday the 9th at chapter 11. So
okay,
awesome.
We got to decide what book we're going to do next here pretty soon. We're going to start cruising through these last chapters.
We're almost we're 330 pages in, 340 pages in, so we're just about to the halfway point. So
yep.
Surveying
boundaries.
Yeah.
A little thicker.
Yeah. Right.
I was thinking something small like Waddle, like a little simpler one to kind of break up.
That would be a great one.
No, Waddles would be
Waddles
great.
would be a good one.
That would be a great one.
Yep.
We could have some really good discussions on that one, because that's we've only had a few like legal description type stuff on Mentoring Mondays, and so I think a whole conversation on the Waddles book, I think that would be awesome. So maybe there you go.
Okay. Well, awesome. Great. Thanks, guys. We appreciate you.
All right. Have a good night.
Thanks, guys.